Yes, that's gone quiet. That's all right, Crystal. It was just a little bit of noise in the background. Is something happening there?
Yes, I've had to connect into my mum's place and she backs onto the main street. So
Oh,
I've just
right.
shut it now, so it should be fine.
Yeah, that's okay. It's not a problem. We get that sort of background sound from time to time, but so long as we just have our mics on while we're speaking, that probably makes it easiest, I should say. Steph is here, but she has no. Steph, I take it that when you say you have no sound, does that mean you have no sound from the loudspeaker, or you have no sound from your end? For the rest of you, I'll just give Steph a moment to try and organise her audio. Apparently, she can't hear. Um, I noticed, Robert, you're showing with a mic there today. Um, it's good to see a number of you here. There are only 18 enrolled, so this is a decent number for a turnout. I noticed, at least when I looked earlier today, only a couple of you had um, only a couple of you had contributed to the online forum, um, which is due to close up at the end of the week. That'd be. I'm really asking Crystal, Robin, and Robert. Are you in a position where you're going to get your contributions to the online forum about international company law going this week?
Yes, I am. All my information that I sort of gathered together is on a USB stick, which one of my employees broke. So it's currently in a lab in Brisbane with the information being extracted. So I'm hoping to have that back on Tuesday, in which case I can upload my stuff. But in the meantime, if they can't, I am still doing some research. I'm finding it really difficult to research American stuff. That's where my interest lies. So I'm trying to push myself to find that information. But I guess because they're not governed nationally, everything is by state. It's also vast and different.
Yes, there could be state differences. I'm not sure exactly about the breakup. I'm sure that there are federal laws relating to companies, but I'm not sure about the breakup in America. Yeah, so it could be complicated there. Of course, the assessment task also involves um, the assessment task also involves commenting upon other people's contributions. So while you're waiting for your stick to be recovered, it may be that you can get into commenting on others as well.
Yeah, we'll do so.
Okay. Now, I'm just trying to see um, how Stephanie's going there. Yes. I don't think she can hear me, so I should try and type something. Um, And Robert, this might be an opportunity to check that we've got contact with you. I think you've added to chat that you're on top of your contributions and ready to go. Is that correct? Robert, are you there? I've got your microphone flashing here now.
Are you talking to Robin or there's a Robert?
No, Robert. Robert.
Okay.
Are you there, Robert? Robert's saying he's not ready. Okay. Well, I think we're going to need to start. I realise that one or two others. Right. So, Robert, just to clarify, Robert, you're showing up as having a microphone here, but are you trying to use it? I'm not hearing anything. I don't think anyone else is either. Oh, you don't have a mic. Well, that's curious, because under participants here, it's showing you as having a mic, which is actually on. Maybe that there's some internal mic to whatever you're using. Okay, we better proceed with this. We'll get on to tutorial problem 1. Now, the issue that I wanted to raise with tutorial problem 1 really is, well, perhaps somebody could summarise for me why it is that the court decided to pierce the corporate veil in the case of Guildford Motor Co against Horn. Robin, do you happen to be on top of that issue?
I think so. I sort of thought it was because the only reason he started up that company was to get around that limiting, I don't know the word, that was placed on him. So he wasn't allowed to do it. So the only reason he started that company was to get around that. Yeah, and it was really clear.
You're thinking of the restraint of trade clause.
Yes.
You did restraint of trade clauses in contract law, I take it?
Yes, we did, I think.
I think. Okay, well, just to start. In any event, they often resemble what was there in the Guildford Motor Co case. They can be anti-competition clauses or clauses about not approaching customers. You could argue that not approaching customers is more specific than restraint of trade, but the effect is restraint of trade clause. But have any of you read Salomons case? I don't mean the entire case, but the report of the case. Crystal, did you have a look at Salomons case?
No, I didn't, not yet. I listened to your podcast though, I found that very interesting about it.
What about you, Blade? Did you have a look at Salomons case? Blade, have we lost you? Never mind, he might be back. Steph, I notice we've got you in touch now, so why don't we hear from you? You know what we're talking about?
Hi, can you hear me?
Yes, I can.
Oh, great. Yeah, Salomons case. And we're talking about restraint of trade clauses.
Well, not so much restraint of trade clauses, but do you remember that the argument that was put in Salomons case that lost? Do you recall the argument that was put there? It was actually very similar to the argument that Horn put in the Guildford Motor Co case. Why?
Couldn't hold.
Sorry, go on.
Well, I'm just trying to think. He couldn't. This is part of the entity, the shielding. Salomon was accused of hiding behind the corporation to secure his investments over and above the unsecured creditors. So, no, I'm not really catching the argument when it came to restraint of trade.
No, sorry, there wasn't any restraint of trade in Salomon. But in Salomon, remember that the Salomon case was only won in the House of Lords. It was lost in the Court of Appeal and on trial. And the argument that was put that succeeded before the Court of Appeal was that the company was just set up as a sham, and it really was just Mr. Salomon. That was the argument put in Salomon's case. And that argument lost. So can anyone suggest why the same sort of argument should be successful in the Guildford Motor Co case, but not in Salomon's case?
Well, they found Salomon's case wasn't a sham because he was carrying on a bona fide business. He wasn't in any breach of fiduciary duty or any contractual obligations. He was simply carrying on his business and then, became bankrupt. So there was no actual loss of good faith in his dealings.
Well, they were in breach of contractual obligations eventually, weren't they? Because they weren't paying their creditors. So when they went bankrupt, when the company went bankrupt, I should say, it was breaching all its contracts with creditors to pay them. So can you suggest why? Well, I think you might be suggesting why, but perhaps you could elaborate why in Salomon's case it was okay to breach contracts with creditors, but in the Guildford Motor Co case, it wasn't okay to use the company to breach contracts with his former employer.
Are you happy for me to continue?
Yeah, sure.
It's just that I think that there's seems to be a lack of an issue of insolvency in the Guildford case. The Guildford case was clearly where they found that Horn was set up a company specifically for the purpose of avoiding this contract he had, where he wasn't supposed to take customers away from Mr. Guildford's company. Whereas with Salomon, he wasn't taking customers away from another person's business. He was merely borrowing money.
Well, I think you're being a bit specific, aren't you? I mean, what you said is entirely true, that's a difference to the surface facts of those two cases. But the Salomon principle wasn't limited to contractual obligations involving money or credit, was it? I mean, the basic principle that Salomon laid down was that the company is a separate legal entity, apparently for all purposes. Wasn't that the outcome of that? Perhaps I'll pick on somebody else. Crystal, what do you think about that?
I had a little bit more research on the Guildford Motor Co. More than I did look at the Salomon case. I just found with the Guildford, there was a quote by Lord Handworth that I wrote down, and he stated that in law the company was separate to the individual, but in this case he felt that the company was created as a device, a stratagem, in order to disguise the effective carrying out of the business of Horn. I just thought that was really interesting.
Yeah, so I think that's when we analyse these things, and one of the reasons I was referring to surface features is that when you're reading a case, you need to abstract the principle to the correct level of abstraction. I mean, you can always distinguish cases on their facts in the sense that the facts in one case are never the same as another, but it doesn't follow that the rule in one case won't apply to another. You've got to work out the level of abstraction. I would have thought that part of the level of abstraction seems to be that in what I think you're saying, Crystal, is that in the Salomon case, at the time he set up the company, he didn't have any existing contractual obligations that he was avoiding through the use of that company. In the Guildford Motor Co case, he had an existing contractual obligation, which he was attempting to avoid by setting up the company as a device. Now, some people would say that companies are always devices. They are artificial legal persons, after all, so they're sort of bogus in that sense. But it does seem to me that that's one of the principles, if not the only principle, to distinguish the two. That the contractual obligation in the Guildford Motor Co case was existing at the time that the company was set up, and the company was set up to avoid that obligation. Now, I think 2 points arise from that. One is in the Salomon case, what you're really saying, I mean, in the Salomon case, when you set up, or put it even more generally than that, when you set up a company to get limited liability, the implication of that is that you won't have any personal liability for the debts if the company doesn't meet its obligations. So it's implied in that you're setting up the company to potentially avoid future contractual obligations, aren't you? That's why I asked the question, well, what's the moral principle that divides these two? Bearing in mind that the Court of Appeal in Salomon's case was horrified at the idea that Salomon would be able to do this. The second point I think it raises is that if you look at the facts of the Guildford Motor Co case, they're not as simple as we're describing. He set up a personal business first, which did appear to be breaching the contract. He then apparently consulted his solicitor, and the solicitor asked for a copy of the contract with the restraint of trade clause in it. And shortly after that, he set up a company in the name of his wife and an employee, I think it was. If you look at what the judge said about the case, well, they started talking about the company as being a sham, which was really just Mr. Horn, even though he put these other people in place, which looks very much like the argument that was put in the Salomon case, that it was just a sham. The company was really just Mr. Salomon. That was the argument put in the Salomon case. So it is, in fact, a somewhat subtle point. Obviously, laws are based on concepts of justice and wrong. Did any of you think that the decision in Salomon's case was unfair? Have we got you there, Blade?
Yes, I'm here. Can you hear me?
Do you recall the Salomon's case, the basic principle of that? Why is it all right in Salomon's case to set up a company to potentially avoid liability in the future for contracts, or limit liability in the future to contracts, but it wasn't all right in the Guildford Motor Co case?
I'm not sure, sorry. I've not looked at the Guildford one, so I can't comment on that.
Well, put aside the actual specific cases. Do you think that you're acquainted generally with the principle in Salomon, aren't you? That it's separate legal entity, limited liability?
Yes, yep.
Do you see anything wrong with that?
No, I think that it's good that there's a separate legal personality, personally.
And so if you were one of the creditors of a company where you dealt with a person, they incurred a debt, they owed you $1,000 and they said, I can't pay you, the company's broke, what would you say is the fairness of that position? If you had a creditor sitting in front of you and they're your client and you're telling them this, how would you explain to them that, well, this is all okay, this is the way that business is normally done?
I guess that'd be a tough conversation. Obviously, when you have a client, you don't get to choose what facts they bring to the table. But I do think that when you are dealing with a corporation, especially if you are a creditor, you should understand the potential risks involved. And corporations have been existing for long enough for this not to be such a new thing. I think that Sorry.
Yeah, we just lost you momentarily there. I wasn't intending to interrupt, but I think I've got your drift. I think you've actually raised another significant difference, though, haven't you? That in Salomond's case, when the creditors were dealing with the company, once it was already established as a company, so the contractual obligations they incurred were incurred knowing that they were dealing with a company, whereas the contractual obligation in the Guildford case was incurred personally by Mr. Horn, and the company was used to evade it in that sense. So that's another potential point of difference. The trouble with that argument, though, is that the corporate entity, the separate corporate entity, also applies to tort law, doesn't it? So if you're harmed by the negligence of a company and you sue the company and it has no money, you didn't really choose that tortfeasor, did you? You didn't sort of say, well, I'll get run over by this company driver as opposed to by somebody else. So there are problems with the justice issue there in relation to
Absolutely.
and
Yeah, sorry to interrupt. Yeah, absolutely. But I guess that's why work cover is so important and insurances are so important from a tort perspective.
yeah. Well, there are a range of torts. So work cover would cover employees for harm to them, and of course, compulsory insurance for motor vehicle accidents would cover them. There is some scope for compulsory insurance to protect parties from this, isn't there? But compulsory insurance at the moment is rather limited, but maybe there's some scope with that.
Yeah, sorry, I wasn't trying to get too far off track, but it's just an interesting point because even if you deal with Medicare at a injury level, they won't go ahead with the claim unless someone is insured and they are able to get money back from the insurer. It's off topic there, but I'll let you bring it back.
Yeah, I'm not sure what you're referring to there. Medicare itself you're entitled to, but you, at least I haven't filled one out recently, but you used to have to fill out a claim form saying, is this covered by a damages claim of some sort, or do you have some sort of claim or workers' comp or damages claim in relation to this? And the basic principle was that if you had a common law claim where you could recover your medical expenses, then Medicare would come after that, or they'd actually have a charge on it. From memory, they had a charge on it in the solicitor's bank account when the damages were recovered. Medicare had to be repaid, which is why they had an interest in it. But the actual compulsory insurance, there might be some exceptions I'm overlooking, but there's compulsory workers' compensation insurance, which normally covers common law actions as well, and that protects employees injured in the course of work who might be able to sue their employer. So that covers that relationship. Obviously, with motor vehicles, there's cover through compulsory third-party insurance, which covers injuries, not property. Apart from that, off the top of my head, I can't think of any other areas where compulsory insurance is. The other area, of course, is in relation to professionals. They have professional indemnity insurance, but at least when I was in practice, they weren't companies. Nowadays, they can incorporate, but they have personal liability anyway. So that's...
Yeah, one of the things that I didn't explain myself properly, I apologise for that. But for example, in a public liability instance, say if you slip over and at, let's say at Woolworths, even though they do have insurance, but let's say if they did not have insurance, then Medicare won't necessarily progress that claim, and it can cause a lot of trouble. So I guess it is good practice to have insurance. So I guess I was trying to answer your original question about talking to a creditor looking to recover their loss, but basically, yeah, I was trying to answer that a little bit. So I'm sorry for taking that off topic anyway.
No, that was all right. I didn't regard it as off topic. I was just needing a bit of clarification, so thanks for that. I'm just looking at the chat forum here. Robert's made a couple of comments about the difference lies in intent, the intention to avoid duties. And I think that really sums up the proposition I was putting, that the key difference seems to be the intent at the time that you set up the company. That seems to be the key issue. But it is an interesting moral issue, nevertheless, that at the time you set up, there are people who still argue that the protection given to companies through limited liability is in fact immoral, effectively, or at least unjust, they would say, because effectively you shift the risk from the investors to the creditors. That's all you're doing. I mean, you could argue that the investors know they're dealing with a company as well, running a business, and they're the ones that make the profit out of it, so why shouldn't they pay? But that's a much deeper argument than I was intending to go into here. I noticed Steph has made a comment there. Perhaps you could elaborate on that, Steph. Creditors are not the main party to a company's contract. What do you mean by that?
Well, okay, I understand the moral argument, so I'll avoid that. Section 140 of the Corporations Act, the effect of a contract is between the company and each member, and the company and the directors and the members and other members. So creditors aren't even in the list. Now I know that's we're not talking about common law here.
No, I think that you're misreading that section.
Oh, okay.
That's referring to the Constitution. The Constitution forms three contracts. There's the Constitution itself is a contract between the company and the officers, which is primarily the directors, the company and the members and each other. So each member has a contract with other members, but the actual terms of the contract are the Constitution. That's why the creditors aren't mentioned there. It's not talking generally about company contracts. It's talking about the Constitution. They're binding as contracts. And of course, the reason it says that is that it's telling you who can sue whom. You've got it because of privity of contract. You have to have a contract between you in order to enforce it. And the key thing that follows from that section is that there is no contract in the Constitution between the officers and the members. So if the directors, for example, act outside the Constitution, they can't be sued by the members under the Constitution. We'll see when we do directors' duties that the same sort of thing applies. The directors' duties aren't in the Constitution, or not normally, but those duties are owed to the company, and only the company can sue for those breaches. Have you understood that?
Yeah.
Yeah. So that doesn't apply to what we're dealing with here. I noticed Robert has added a comment, and of course, which trumps my suggestion of a moral status, economic. It's all about economics, isn't it? Incidentally, I want to say that I don't think that you should imagine that when we're discussing law, when we're learning about it, we shouldn't talk about moral issues. One of the ways of understanding law is to look at what is the mischief that it's addressing. That can strengthen your arguments greatly. But put it another way, if you try and use laws to achieve things that they're not intended to achieve, you can often get yourself into hot water. And the arguments that flow from that are often weak, and there can often be unintended consequences as well. But certainly when we're learning about the law, we do want to talk about, I called it, it's fair enough to say, well, it's not morality, it's justice or something like that. But I think it is, whatever you call it, it is important to look at what is the mischief that it's trying to address. And we understand it better by doing analyses like saying, well, look, fair dinkum, is Guildford Motor Co. all that different from Salomons case? In many ways it looks similar, the arguments look similar, and it can be useful to us to look at the differences. But Robert's, in a sense, put his finger on exactly why it is that the moralities of the issue in Salomon's case were trumped, and that's because the economics trumped them. There are strong economic bases for having limited liability companies, in particular having capped investments, allowing passive investors to invest their lazy capital in investments without being exposed to unlimited personal liability and without having to be experts in the area. Now, Steph, you've got a question. You don't have to ask permission. You can just butt in if you like, an appropriate moment.
Look, it's a little bit of a daft question, I guess, but you're saying that the company has to sue because there's no contract between the officers and members. The members, say the shareholders, can't sue the directors, the officers, but the company must sue the officers. But isn't the company owned by the members?
Well, in a sense, that's right. That's true. But it's not run by the members, it's run by the board, isn't it?
Yes, but the board isn't going to sue themselves.
That's right.
I'm just...
There are actually two answers to your question. You've put your finger on the pulse of something. That the board will often be in conflict in the sense that they run the company. So if they're in breach of duties or acting outside the Constitution, they may well not want to bring the action in the name of the company against themselves. Now, that is something that we deal with later in the course. It is possible for a member to get permission from the court to bring a derivative action, but it's still an action in the name of the company. See, saying it's an action between the company and the directors isn't just a matter of who controls it. It's also a matter of how you calculate losses. So even if you're a member bringing a derivative action in the name of the company against the directors, you don't sue for your own losses, you sue for the losses of the company, which might be quite different. So it's not just a matter of control. It's even if you get someone else to control the action through a derivative action, it still is a company action, not an action by the members directly. Well, we've actually strayed quite a distance. In fact, you just dipped your toe into Module 7. I happen to have just revised the notes for Module 7 last week, so I know that derivative actions are referred to in Module 7 and the notes have been uploaded. But that's good. These are all things that flow from the idea of separate legal entity, don't they? Now, I think we've covered most of those things. They're an extension of things that we've covered before, but we're looking at piercing the corporate veil this week in that question. Did anyone have any further questions about problem 1? Excellent. Silence. We'll go on to problem 2. Now, I suppose it has been argued that people who set up companies should be able to make a profit out of it. They should be able to do business just like other business people. Business is not always all that attractive. Sometimes it looks pretty grubby, but that's how people make their money. So I suppose there's a fundamental question of why should promoters owe fiduciary duties to a company that they're about to form? Could someone suggest an answer to that? Robin, we haven't heard from you for a while. Are you alive, Robin?
I'm alive. I'm just thinking.
Okay, well, let me take you through it. I take it you're sort of vaguely, at least vaguely acquainted with the case of Tracy against Mandalay, the High Court decision.
Yeah, I am. I've read it in the Redmond textbook, but I found it really confusing to read. So I haven't quite got my head around the case. Yes,
I could understand that. the extract, on this particular case, the extract in Redmond is, I think, almost the entire decision. On other cases, it'll only be a small portion. First issue, I suppose, is did you get your head around the idea of what a promoter is? Did you get that idea?
Yes, sort of, I think.
So can you tell us what a promoter is?
The person who sets up the company. So they're responsible for making sure it gets incorporated, finding the investors, that sort of stuff.
Yes, that's correct. It's actually on page 160 of Redmond, the passage, which was taken from the Twycross case from memory. No, they've taken it from Emma's Silver Mining, which quoted Twycross and Grant. Is now clearly settled. The persons who get up and form a company have duties towards it before it comes into existence. Now, the case also dealt with passive promoters as well, and that again might raise issues for us. But putting aside the detail of the Tracy and Mandalay case, Tracy and Mandalay case is instructive on the point that you just mentioned, that if you want to practice law in the area of business, they all look like this, the cases. They're never simple. They're not like the carbolic smoke ball case. Oh, for those days. They're much more like this. And this case is from the late 1940s. So you can imagine the sort of dealings that go on in business today. So on the point of the complications of cases, you do need to practice understanding these sorts of cases. When I read this case, I read it again today, but when I took up this course last term, I had to read it again in detail, and I had to sit there and make notes on who the hell everybody was. And of course, today I had to sit down and read it to remind myself, because there's so much detail, you can't remember it from one term to the other, exactly who did what and when. Robert has raised an answer to my question that, and I think actually he's put his finger on it. The promoters set up a company, and at the time the company's set up, the dealings between the promoters and the company are either finalised at the time of setup or shortly afterwards. In this case, the company was set up and there were some board meetings and a general meeting just shortly after the setup of the company, which all approved this contractual arrangement for the sale of the land. We'll call it the sale of the land. In the end, it was actuated by a sale of land at a very low price in order to evade income tax, and also sale of shares. And the sale of shares was going to make up the bulk of the returns on the land that would provide the profits. Now, at that stage, effectively there were no non-participant shareholders. I mean, participants in the promotion. The only shareholders were people who were in some way involved in the deal relating to the land, the promotion of the company for that purpose. So I think the starting point of the investigation is to say, as Robert has said, that the investors, the ultimate investors, are the people who invest in the company. They have no knowledge of these, well, they don't even exist at the time the dealings took place, and they don't necessarily have any knowledge of the dealings when they invest in the company. But what about this argument, though? Why shouldn't the future shareholders just be required to rely on their own due diligence? Perhaps you could answer that in writing, Robert, and I could pick on somebody else to try and answer. Crystal, could you suggest an answer to that? It can happen not only with shareholders, but also creditors. The typical situation is that the company's set up and obviously something goes wrong. and it goes into liquidation. Now, in this case, it was shareholders. In a liquidation, will often be creditors who want the company to exercise their rights against promoters to get more money into the company. But why shouldn't they just be subject to ordinary due diligence when they decide to buy shares or to enter into contracts with a company? Why should they be able to go back in retrospect and say, well, look, that dealing from the past before I was there wasn't valid? Can you think of a reason for that, Crystal?
I'm just sort of thinking very basically. A couple of years ago, I was working and my boss was big into shares, but she didn't have a great understanding, and she'd be on the Westpac page just buying different shares and selling them off. But, you know, for the common person, would they be reading the rules or going back through and requesting the financial records to see what the company was doing before they invested in the shares?
Yes. So I think you're getting to this point then, and I think this is a critical thing in the policy that surrounds the corporations law. When I'm investing in Westpac, by a complete fluke, I actually have shares in Westpac. In fact, they're the only shares I have. Now, when I buy shares in Westpac, am I just totally left to my own devices to ascertain whether that's a good investment or not? Or to put it in another way, what protections do I have?
Is a key point here the fact that you can't, because it is a startup company, there is no records, there's no prior financial anything to go back and look at. So if you're going to invest in this company, all you've got to go on is who those promoters are or who's going to be the director.
Yes, that's right. And that was the point I was getting at. And I might say that this discussion, a lot of the time I'm expressing my own views on this. I'm not saying that everyone agrees with it, but I think that if you're looking at the policy of the law, and something that is a very good practice when you study law is to figure out why is this so? Why is it done in this way? Because you then develop a much better understanding of it, and it allows you to develop arguments in the future. When you're in practice, you're not told, oh, this is a case about promoters. You've got to figure out what happens is that you're presented with a mischief or something the client tells you is a mischief. And you then need to find the law that matches that mischief. And because the law has centuries of history, it does have a law to match almost every mischief. But it might not be written the way that your client would like it to be written. In some situations, you'd be saying to the client, well, that's your fault. You didn't look into it. You went into this, and if you don't like it now, that's bad luck. You chose to do this. But I think it's true, getting back to promoters, it's true that if I'm investing in Westpac, there are a number of protections available to me. And there's this balance in corporations law throughout the whole thing. And the Australian corporations law does a pretty good job of it, that there's this economic drive for the use of companies, the liquidity of investments in shares. You want low transaction costs when you're transferring shares and buying shares. But there also is the risk that when you have an investment that is so easy for passive investors to get themselves involved in, and they have no role in management or knowledge about management, there's a risk that they can get ripped off. So the corporations law has this balance throughout it, everywhere. Later on, you'll learn about a number of these protections. One of them is that the company is a separate entity, which is a danger, but it has a board of directors who owe duties to it. And so if you're looking at the issue of, well, has the company entered into an uncommercial transaction, you'll see that there are laws against uncommercial transactions with directors to protect shareholders there. But say it's an uncommercial transaction with somebody else, the protection you've got is that the board owes a duty to the company to act in its best interests. And so you're supposed to be able to rely upon the board to represent the company so that the company doesn't get ripped off. And that's what happens here. Even though the shareholders are the ones complaining, it's the company that's been ripped off in Tracy against Mandalay. And it's been ripped off because the promoters of the company acted in their own interests and not in the interest of the company. And in fact, some of them became directors as well. And so in the startup company sort of situation, the issue you've got is that there is no established board of directors. And as you said, there's no history to go along with it, to back up what's going on. So you have no history of any records of what's gone on, other than the actual bald transactions. You don't have a history of the board of directors themselves doing due diligence, because at the time the transaction was being looked at, the company didn't exist at the time. So that's one of the reasons why promoters are regarded as having a fiduciary duty to a company to be formed, because a company in that situation is in a particularly vulnerable situation, and where it has no choice but to rely upon the people who are setting it up. It can't do anything else, and therefore you end up that idea of reliance often leads to a situation where somebody is regarded as owing a fiduciary duty. I take it that you probably haven't studied fiduciary duties before. They're hugely important in equity. I presume you study them in equity. Has anyone studied equity?
Yes.
Yeah, I'm doing it this semester.
I presume that it would be in the equity course. Of course, it'll also be in the trust course, because trusts are a form of fiduciary relationship as well. So learning about fiduciary relationships is hugely important. It's very important in companies, because the company is an artificial legal entity. It often places faith in officers and promoters and people like that. But fiduciary relationships are also important in other situations. But what about this issue? Well, where does that place us with the idea, though? And this was argued in one of the journal articles. I wouldn't expect you to read it, but at this stage. But comes back to this argument. Well, how do promoters make money? In this case, for example, Mr. Salon appears to have done a huge amount of work to try and get this company up and running. Why shouldn't he be able to profit from that? If you look at it from his point of view, it's a sort of an entrepreneurial promotion which he wants to make money out of. Why shouldn't he make a lot of money out of it? Did anyone think that this case was unfair? Who else have we got here? Steph, haven't heard from you for a while. Do you think it was unfair?
Well, I found the discussion about the minor shareholders. Let me see my notes. There was a Miss Whippy and a Mr. Griffith.
Griffith, yes.
Yeah, and the High Court did have a question mark over their involvement, whether they were actually active participants, in this adventure, this scheme, and decided that they actually were, even though they didn't really have a lot of knowledge of what the Salon family were doing, because they had to, in order to recoup their money of their original £10 investment, they had to really, like they were on a train to hell then, they really had to keep following along with the Salon family in order to and keep on track with all these questionable schemes in order to recoup their original investment. Is that answering the question?
Well, yeah. Well, I certainly think that you're getting on to, and it is answering my question about unfairness. I've just noted incidentally that Blade was wanting to say something, so I'll give him an opportunity in a moment. But yes, you're on to the point that I'm raising, that did you think it's unfair? If you're looking at,
I'd call.
Yeah.
Sorry, yeah, it was a hard call on the minor players, what they're calling, I think of them as sleepers, but I think one text calls them dormant and others inactive promoters. And because there's no clear-cut definition of a promoter, really, even people who are just perhaps even being misled and manipulated themselves might even find themselves categorised as promoters.
Yes. I do think that that statement in the case that there's no clear-cut definition is, it's true that there's no rock solid, word perfect definition of a promoter. But I think that we have a fair idea of what an active promoter is, somebody who sets the company up for a particular venture, stuff like that. Twycross and Grant is normally quoted in that respect. But
it is a bit edgy.
Sorry, go on.
Can I just say that it's a bit of a grey area, because the promoter is perhaps the marketing person, and a marketing person really needs someone like a Miss Withy in order to do the office work for them. So Miss Withy then is brought into their net.
That's right. Although, it wasn't that she did the office work. What I was going to say is that it seemed that the High Court regarded Griffith and Withy as promoters, passive promoters, I think we call them these days, simply because they were participants, passive participants in the venture, the profit-making venture. And the profit-making venture was a promotion venture, and so they were promoters. But I might try and get Blade in here to see what Blade, and I don't mind, incidentally, Blade, I don't mind if you want to go back over old territory to make the point that you were going to make, and I overlooked your presence earlier.
Yeah, thanks. No, that's okay. It was a little while ago. I was just going to mention, when you talk about fiduciary duties, along with obviously that derivative action that is available through statute, there's also a lot of personal actions that can help minority shareholders and shareholders in general. But yeah, that was a little while ago, so I'll let the...
That's correct, but those actions are not brought against the directors. So the same privity issue arises.
Derivative actions can be...
Yeah, in a derivative action, a shareholder, it's normally a shareholder, it can be others, but it's normally
the directors, can they not? Because they're brought against the company and the directors are controlling the company. So I thought derivative actions obviously...
In a derivative action, you're not bringing an action yourself as a shareholder, you're bringing it in the name of the company. The remedies that you're talking about for shareholders, they're brought against the company, not against the directors. So the members don't have any direct actions against the directors at all.
But they can make those actions for the company against director oppression.
Well, no, I think at least you're going in dangerous territory there when you talk about director oppression. There are two situations. There are duties owed by directors to the company, and the company can enforce those duties. Now, the company acts through the board, so if the board in some way is complicit, then somebody else can get permission to sue for the company. Those aren't oppression actions. When we talk about oppression, we're normally talking about the controllers of the company, or including majority shareholders, oppressing minority shareholders. In that case, those are actions by the shareholders on their own account, and they're brought against the company, not against the directors. So mixing the idea of suing the directors for oppression, that's the difficulty I have. You don't sue directors for oppression. If you've got an oppression action, you sue the company. If there are complaints about the directors, the company sues the directors. So you just need to distinguish those things. That's part of the idea of the corporate veil, the that there's a separation between the board. The board's supposed to be independent and owes its duties to the company, not to shareholders. They're independent of the investors, and that's why there's no direct link between investors and directors. It is correct to say that some actions that are oppressive to minority shareholders will also be breaches of duty to the company. So, for example, if the directors refuse to issue dividends and increase their own remuneration, then that could well be a breach of the directors' duties to act in the interest of the company, but it could also be oppressive to shareholders. It would mean the company could sue the directors for breach of their fiduciary duties, and it would mean the shareholders could sue the company for oppressive action. But we are drifting into Module 7, so we're getting somewhat ahead of ourselves here, or Modules 5, 6 and 7, as a matter of fact. Getting back to this issue of passive promoters, it did seem that the only reason that Griffith and Withy were held liable in this case was because of participation. It wasn't anything more than that, was it? It was just mere participation. And in the end, I don't think they made any money. As I read it, at least one of them lost money. They had to sue. In any event, whatever they got out of it, they had to sue to get it anyway. So they certainly didn't make money out of it. But the court held that they were passive promoters and therefore liable for breach of fiduciary duty as well. Now, did anyone else, for example, Crystal or Robin, did you have a look at the position of the passive promoters here?
I didn't get much out of the textbook, so I actually went and read through the case twice today in full. But I still, it's such an intense case that the only bit that I got out of it, I actually went into a separate case note for it and just referred directly back to Twycross and Grant and the definition they gave by Cockburn for a promoter. And that was one who undertakes to form a company with reference to a given project and to set it going, and who takes the necessary steps to accomplish that purpose. So a shareholder who provides funds presumably may be able to go under that.
Yes. The normally that's what you've just quoted is what I think of as the standard definition of promoter. And you'll note that the High Court says, or quotes another case saying that there's no definition of a promoter, and it actually cites Twycross and Grant. I think if you look at Twycross and Grant, what it really says is, well, there's no black letter definition of a promoter, but what you just described is a pretty fair working definition, isn't it? Which is what I was saying, that you can use that definition fairly handily to figure out whether somebody is a promoter or not. I think the cases leave open the possibility that others are included. Normally, passive promoters would be regarded as being separate from that definition. They'd be regarded as falling into the category. Normally, that's regarded as a definition of an active promoter, and a passive promoter is someone who participates. But in imposing the duty on the passive promoters, it then does raise questions about, well, you can't really say the company was relying on Griffith and Withy, were they? So to say that the fiduciary duty of a promoter is based simply on the fact of the vulnerability of the company and the reliance that it has to place in the promoters, that then raises question marks about passive promoters, doesn't it? Because that reliance, well, the vulnerability is still there, but the reliance is not. The way I would read the High Court decision is that the notion is that the participation is like a form of collusion, isn't it? that the reason they're roped in is because they're taking part. It doesn't matter. It doesn't matter whether they didn't do any of the stuff. They leapt onto the bandwagon thinking that they were going to make a profit, and so effectively they're accessories. Not that the High Court wouldn't dream of using that word because it's a criminal law word, but effectively the notion is the same, isn't it? That they're just accessories during the fact, and they stood to make a profit out of it, even though in the end they ended up failing. So, Crystal, did you end up having sympathy for Griffith and Withy, or none at all?
Not really. In section 24 of the case, they've got there that it says that it is clear that they agreed to participate in the scheme to promote the plaintiff and sell the land and the shares to it, provided Mr. and Mrs. Salon gave them the promissory note so that they would not lose out on their investment by selling their shares at £8 to 12 ounces. And it goes up further that Miss Withy wasn't aware that she held a minor position. She only had a hazy idea of what was going on. But you must have had an idea of attending a shareholders meeting. It wasn't just people going out for coffee.
Yes. Well, the thing that struck me about it was that they were told the land cost £8,000. So apparently it actually cost £6,000. And it was going to be sold for £28,000. So it's not as if they might not have done anything, but they knew a lot. Now,
I kind of feel like it was. Sorry, I was just going to interrupt, and it sounds a bit like a gamble. Like they were kind of gambling. Like, how often do you get that sort of return on your money without some kind of risk?
Yes. Well, it may have. If you look at the facts in retrospect, it definitely was a gamble, wasn't it? Because it wasn't a certainty. But I get the impression that when they went into it, it was presented to them as a certainty. The only thing they were gambling on was the fact that the guy that they were dealing with was, shifty. So the goalposts kept shifting all the time, and the deal kept shifting. But just following up on the point that I was making earlier, though, it might seem a bit too simple-minded to say, well, why can't promoters make money? But the case presents that the land was bought for £6,000, and it was, and the Salon told Griffith and Withy that it was bought for £8,000. But what's also, and it was going to be sold for £28,000 later. But there was also a lot of work going into this promotion, wasn't there? Firstly, there was an entrepreneurial idea of building this block of units at Potts Point. Now, that in itself is, some people would argue, well, that's an entrepreneurial idea. Why shouldn't you make profit out of that? Why should it seem odd that you would then only sell the idea for £28,000 rather than 6 or 8, the 6 that you paid for it? But also there were dealings with the Maritime Services Board about some land that was providing a view of the harbour, and they ended up buying that. So there were things done by the promoters here. In modern times, if you got people to do that for you, that actually cost a hell of a lot of money to get that sort of stuff done, liaising with the government and liaising with architects, not just about building a building, but building a new style of building in the area. All these things were happening. So you could argue that the High Court puts it a little bit too simplistically, but in the end, that's the lesson for promoters, isn't it? That it's not easy for promoters to make money out of those positions. And that's why when you take up any fiduciary position, it's often said that the only person who can't profit from it is yourself. Other people can make profits from contracts and entrepreneurial activities, but not when you have a fiduciary obligation.
Can I interrupt quickly? Could you then go in as a supplier to the company as well? So once the company is up and running, you invoice your services to the company that way?
Well, that actually brings us to the final point I was going to raise. That say you did have a promoter who came to you to seek advice in this situation, and say they wanted to do that very thing that you've described there. But it'd be quite common that promoters want to sell land to or other major property to the company. That's quite likely to be the situation. That's quite likely to be why the company's being set up. So how do you do this legally?
An employment contract?
Well, it'll be by a contract, but how do you make, there was a contract in this case, wasn't there? And it was declared invalid. How do you make the contract valid? Robert's put a point here that promoters can make money by giving notice. Can someone, since Robert is limited to the written word, can somebody expand on that? Who gives notice to whom?
The promoter to the shareholders?
We'll go with Robin first.
I was just going to say the promoter to the shareholders or the investors?
Well, there aren't any shareholders or investors at the time that it happens, is there? They're only coming along later. Steph, you were going to say something.
Oh, I'm just having a guess here. Is it the information supplied in the prospectus? Is that how you pronounce it? Prospectus? Yeah.
Yeah, where did you get that from?
Through my studies today, and I'm trying to think, was it out of the Corporations Act or was it in commentary?
You've done some wide-ranging reading, haven't you, Steph?
Yes, and it does confuse me.
Well, as you go, the benefit of that is that as you go through the modules gradually, and you've got confusion now, you'll be able to say, "Aha! Now I understand." Prospectuses are required for public companies, normally ones listed on the stock exchange, to raise funds through issuing shares. So prospectuses wouldn't have, apart from the fact they're a relatively modern development, they wouldn't have applied in this particular case. But still, the principle is the same. But it's the same idea, but it's actually at a different point in time. A prospectus is an information statement about a company and its projected proposals for incoming shareholders. So if you issue a bunch of new shares, you float a new company, say, and issue a bunch of shares to the public, you have to provide disclosure about what the company is and who's involved in it and what its proposals are. That's what you put in a prospectus. And that is supposed to inform shareholders investing somewhat blindly in a company. So it's the same sort of idea, but here what we're talking about with promoters is the company suffering. The company is the one to whom the duty is owed. Now, Robert's on the track here because he's talking about ratification. That's another element of it. But what you find, and this, let me put it in relation to fiduciary duties generally, because one of the things you want to do is be an expert on fiduciary duties. And they're not just applied to this situation. They do have peculiar problems with companies because of the fact that the company is an artificial entity, and therefore the duty could be owed by somebody who's actually in control of the company. But just firstly on fiduciary duties. Fiduciary duties are owed by a lot of people in a lot of roles. The fiduciary has to act in the best interests of the beneficiary of that relationship. In this case, it's the company. When you're talking about contracts, a part of the duty is the duty to avoid conflicts of interest. And nevertheless, though, there are situations where you do want fiduciaries to be able to enter into a contract with the beneficiary. So here, the promoter entering into a contract or having an interest in a contract between the company and someone else. In this case, the promoter transferred the land to the defendant company, which was called RSC Trading Co. And it then transferred the land to Mandalay. So the fiduciary had an interest in the contract in any event. In order to allow that to happen, the fiduciary has to make full disclosure of the circumstances and his interest to the beneficiary, which in this case is the company. And the second element is the beneficiary, in this case the company, has to ratify or approve the contract on the basis of that full knowledge of what it's about. Now, the problem with companies is that second bit about ratification. Of course, it comes into information as well, that in the normal circumstance, the board is the controlling brains of the company, so the disclosure would be made to the board and the ratification would come through the board. And the board is often, at this early stage, implicated in the promotional activity. So that's the problem that we have. Now, there's a general principle, I haven't seen it quoted lately, but there's a general principle to solve this, that if the board is implicated isn't independent, then it's unable to act for the company in giving independent approval of the contract. And in that case, the general meeting of the shareholders would have to approve. This argument, incidentally, was run in Salomon's case. And in Salomon's case, it was argued that when Salomon sold his business to the company, it was at an overprice. And the court held in that case, the House of Lords held in that case, that the initial shareholders, that's Salomon's wife and 5 kids, they tacitly were well aware of that and said nothing about it. So that was taken as being a sort of tacit assent to the Salomon selling his business at the price that he sold it at. But those are the difficulties that arise with companies. And in the situation of promoters, where the board is not in, what the cases say is that if the promoter wants to enter into such a contract, he has the power to appoint an independent board and make sure that they're independent. So that's the easiest way to get around it. It's a bit difficult to use the general meeting to get around it because you don't have any independent shareholders at this point. You've probably only got 2 or 3 shareholders holding 1 share each, so that's not normally a solution. So the solution for the promoter in this situation is to appoint an independent board and to make sure that they're independent, so that you don't have this retrospective invalidation of a contract. I suppose, sorry, just on that point, are there any questions on that? Okay, well, just one final point that I'll raise. It's touched on by what I was just saying. In this case, the shareholders who took the shares, they were also participating in a profit-making venture, weren't they? They were expecting this block of sort of strata title type units or flats to be approved by the government or legalised. And then I think the law changed and it made it illegal to proceed. And that's why the whole thing fell over. And so the company was then looking back and trying to see how it could reverse the situation, which is how it came to focus on this transaction. Did anyone think that that seemed a little bit unjust? That really the only reason it fell over wasn't because of the promotion, but because of the law changing. The shareholders who purchased the shares, they knew how much they were paying, and they were hoping to end up with flats in a unit building at Potts Point. Did that seem unfair to any of you, that they should be able to then go back and blame the promoter for this?
It seems to me that the falling over of the scheme due to the change of I guess it was state government legislation, caused this scheme to be like revealed. Like they would have got away with it, perhaps, if they if the law hadn't changed. So you can't, I mean, when you go into business, when you things like that, the law will change. There will be changes in legislation, and if you're acting dishonestly right from the start, there are chances you may be caught out. But if you're acting according to your fiduciary obligations and you treating investors properly, then it doesn't matter whether the law changes or not. You can then change your scheme so that everyone benefits instead of just the profit-making people dipping out.
I suppose that's the answer, isn't it? There are really two points there. One I think goes one way and one the other. On the one hand, the shareholders knew how much they're paying. I mean, you could argue, well, they were making an investment in involved risk of the law changing. So that'd be an argument against what you're saying. But if they had have done due diligence, they would have presumably found out that the property was bought for £28,000 by the company. But I think the point you're making is that it wouldn't have been apparent to them that this was a gross overvalue. That's the wrongful thing. And if we're looking at disclosure, full disclosure would require more than simply saying I'm selling the property for £28,000. It would have to include saying, well, I bought it for $6,000. You might then say, I bought it for $6,000, but I've done all this work and contributed this idea, and that's why I think I should now get £28,000 for it. You put it to the independent board. I mean, you can put, so long as the disclosure is full, you put it to the independent board and they can take it or leave it, just as you can. They might say, well, we're only going to pay you £14,000, and you can say, well, all right, I won't take it. So that then becomes an arm's length transaction, an arm's length negotiation, doesn't it? So there is that fundamental evil there that the property was apparently sold at an overvalue, but this was not something that was ever apparent to any of the people who were ultimately bearing the risk of this proposal. Did anyone else want to add to that? Okay. Well, I suppose on that question, the closing thing is that when you become a lawyer, if you're advised in this situation, whatever the rights and wrongs of it that we've discussed, you'll have to advise on the law, won't you? And what really becomes very clear from the case of Tracy and Mandalay is that promoters are legally very exposed. They have to cross the T's and dot the I's, particularly in relation to disclosure, full disclosure. Anything that they have a personal interest in, they would have to make sure that an independent board is appointed. And if they don't do that, there's a very good chance that somewhere down the track, if the company for one reason or another doesn't succeed, the liquidator might come hunting for them later. So it is a lesson in the risks involved in promotion, but of course it also is a lesson in the risks involved in investing in startup companies without much information, because the very fact that they have no history and they've got new directors appointed probably by the promoters, that puts investors at a bit of a risk. So maybe the advice to investors would be that they do need to do due diligence about any property that the company has said to own and the valuations of any property in this situation. Okay, now that finishes on that problem. Did anyone else want to raise anything else with me, either about this or any aspect of the course? All totally comfortable. Excellent, excellent. I am hoping, Robert, that you can somehow find a microphone for next time. You're just giving us these tantalising tidbits of your wisdom, and we then can't argue with you because it takes too much typing. So if you could possibly find a microphone next time, that'd be great. Our next class, of course, is on Tuesday. I'm aware that you've got assessment 1 to do, at least, well, all of you have got something to do, but some of you have all of it to do. You do need to get that done this week. Sorry, Steph, were you going to say something?
Oh, no, I might have just touched my microphone accidentally. But on that point, let me raise this on that point. Technically, with the cut-off date being the 21st of March, technically, if everybody put up their submission online on the 21st of March, there's absolutely no real time left for 3 responses.
Yes, I'll take that into account. I've noted that you and Blade have made contributions. Now, what the assessment requires is that you make 3 comments to other people's responses. Now, and they're supposed to be substantial comments, not just one-liners or something like that. I've noticed that you've made substantial contributions. Now, if the situation stayed the way it was, where it's impossible for you to comment on 3 other people because there aren't 3 other people, I'd take into account comments made. Well, I obviously won't hold you to commenting on 3 other people. Just make contributions on what's available there, and I'll take that into account in the assessment. And if it's impossible for you to do what's required by the assessment, then I'll take that into account. Okay.
Peter, I'll just say, Peter, I should have one tomorrow night or Tuesday night at the latest half.
Yeah, well, that'd be great. Another thing I didn't actually say in the specification, but you could take this into account, and I thought of this prior to noting the poverty of contributions to date, that with there's one original contribution you're supposed to make, and that's fixed. You're also supposed to make 3 additional contributions. Now, I've specified them, I think, as commenting upon other people's contributions. That would include developing an argument. If say, for example, Steph and Blade wanted to argue non-stop for the next several days with, detailed contributions about their own stuff, I'd be prepared to take those into account as additional contributions. Similar, and that would include, for example, if Blade says something and then Steph says something about Blade and then Blade comes back and comments upon Steph's thing, well, I'd count that as a contribution, a response to somebody else's contribution, even though the original was his own. So I'm prepared to take those things into account and adjust accordingly. And as I said, if it's impossible for you to do the necessary contributions, then for those particular people, I'd treat the requirements as being eased to that extent. Okay.
I've just got a comment, which I guess after I read Blade, I've stressed, and I've been reading them quite a few times now, but they've put so much detail and a lot of depth into them, and I found them quite scary to read and going, oh no, I haven't thought enough about the assignment topic. I was sort of thinking it was more in terms of just the different types of companies in a different part of the world or whatever, and not so in depth. So I've been a bit scared off by them to respond because I don't know enough about that topic to respond to it.
Yeah, it's not limited to that. I would expect that for most students, because it comes along in week 4, there's a certain level of what we've looked at in relation to companies. So if you're one of the students who does it week by week, then I'd I'd be likely to see you making comparisons with things about the formation of companies and the types of companies and stuff like that. But there's no rule that says that you can't extend it beyond that. You're right that Blade and Steph have done a very good job on their submissions to date. There's no doubt about it. It might be, though, that it may be that you just want to pick up on one aspect of something that they've said and contribute to it. It may even be that you want to agree with some aspect of what they've said and contribute to it. It doesn't have to be an argument or a dispute. The main thing is that what it does have to be, though, is an example of professional research. I might say as well that those contributions are longer than they would necessarily have to be. But the starting point is to try and come up with some ideas. And if you start off by being comfortable in your area and get your submission up there, then that's the main thing. It's true that if you looked at the ones there at the moment, Blades and Steps are of a very high quality. And I can understand you saying you're a bit daunted by that. But of course, the problem that causes that isn't because of the nature of those, it's because they're the only ones there. If more students made contributions, then there'd be some there that wouldn't be that detailed and you'd feel much more comfortable with them. So hopefully over the next few days, you'll have some options. But if not, try and pick on something within those contributions that you do feel comfortable with and adopt a narrow focus.
Can I jump in for a second there?
Yeah.
Yeah, I thought that Steph's was quite good as well, the second one, especially the level of research. And as you can see from my comment from earlier today, I've only really picked up on one thing that I wanted to bring up and discuss to sort of broaden, so I thought it'd be better to narrow it. So I guess it's an example, even though what I've written is probably a bit long, you don't really have to pick on every single thing that's been written or yes or no about it. You can find some things that that come to mind for you or that pop out to you, I guess.
Yeah, that's exactly right, and so just manage around it. The assurance I would like to give, though, is that not everybody's contribution has to be up to that level of detail. Not everyone's contribution has to be to that level of detail. If it is, it's great. But this is very much a free hand in research. It's your group discussion, and you can put whatever arguments you like about it. So you can adopt different approaches. And different people will do that. So certainly, just limit yourself to things that you're comfortable with. And it may be that the link you make with one of the existing comments is somewhat tenuous, but if you come up with some good stuff yourself, that's fine as well. So I think you'll find it easier if we get a few more people putting contributions up there, because then they'll be of different types and you'll understand some of them and you won't understand other ones of them. And you don't have to have a huge long reference list in order to support the point that you want to make. What's more important is the references are solid and good. And so, because I'll be using those. I might say that I'm deliberately not reading them in huge amounts of detail at the moment, because it's not intended to be a discussion with me. It's intended to be a discussion amongst each other. But as of next week, I'll start marking them and then I'll look at them in much more detail then. Okay then. Well, we'll proceed with the, just on that, no further questions? Okay. Well, I want to try and keep up these classes each week if I can. So we will have a class on Tuesday. Try to be prepared with the week 3 materials, and we'll have a week 3 class, and then try to keep them going each week. I might around assignment time. Last term I found I only really wanted to run about 8, because I wanted to run them on problem areas, and certain topics don't really have a huge amount of problems. They're more essay type things, and sitting around talking essays is really just asking students to recite things from books. That doesn't really help much. I haven't made a final decision on that, but I'm thinking that particularly around about the assignment time, it may be that students aren't all that interested in having an online class at that time, but we can talk about that. The approach I adopt is that once we get up and running as we have tonight, the people who regularly turn up are the ones who govern how we run it. And so I'll be guided by you. We can discuss it more on Tuesday about how we want to go ahead. And as I said online previously, I don't mind if people want to raise issues with me, either in advance or off the cuff, but in advance you can raise an issue with me if you want to discuss that as well, and we can work it into one of the classes. Okay then, everybody happy?
Yes, thanks.
Yes.
Yes, thank you.
Okay, we'll finish it there and look forward to seeing you again on Tuesday.
Adieu.
See you later.
Bye.
Thank you.